Can you guys hear me?
Yes.
Calling case number 24-01173 SM. This is the people of the state of Michigan versus Len Derek Tyler Stringer. Mr. Angot, do you wish to place an appearance on the record?
Judge John Angot, I'm here as appointed counsel for Mr. Stringer regarding this arraignment. However, Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Len Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, it is charged by the people of the state of Michigan that in this city of Royal Oak, county of Oakland, and state of Michigan, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compile Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. If the victim is a minor, it is a Tier 2 offense. If you have a prior conviction for a Tier 1 offense, it is a Tier 3 offense. If you have a prior conviction for a Tier 2 offense. This is a high misdemeanor, punishable by up to 2 years in the state prison and up to $2,000. Also, a mandatory collection of DNA identifying profiling samples. There is a count 2 misdemeanor in that on the same date, you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compile Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure. At this time, the court enters not guilty pleas on both of these matters so that Mr. Stringer's presumption of innocence under the constitutions of Michigan and the United States are preserved.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked.
Today's case is one of those courtroom moments where reality feels like a mixture of legal drama, stand-up comedy, and sovereign citizen fantasy roleplay. We've got a defendant who refuses to recognize his own name, claims to be a beneficiary, and believes the court has no authority over him, all while facing indecent exposure charges and multiple warrants out of another state. And trust me, that combination is just as chaotic as it sounds. In this video, you'll watch a judge patiently try to conduct a very real arraignment while the defendant drifts deeper into pseudo-legal mythology. You'll also hear about a criminal history that turns this from quirky courtroom moment into serious public safety concern. There are bond arguments, competency conversations, talk of dual identities, and yes, the unforgettable question, how do you charge a dead entity?
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today. If probable cause is either found or waived at that preliminary examination, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. The court must now set bond in this manner. That's not intended to prejudge or punish you. You are presumed innocent, Mr. Stringer. However, the court must set bond in order to ensure your reappearance to court and afford any necessary protection for the public. In that regard, the court would first hear from Detective Keith Baringa of the Royal Oak Police Department. Then the court would hear from your attorney, Mr. Stringer. Detective Baringa, please proceed.
Thank you. He currently has 2 warrants out of the state of Texas for assault and also in assault with injury to family violence out of Texas. He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation. Several other assault charges, a weapons charge, and then also like falsifying information or government documents. I'm not sure if that's just like a generic false ID case or not, but multiple felons out of Texas. I'm not sure how long he's been in Michigan. He has no current cases out of Michigan that I'm aware of. His criminal history, he has assault from 2019 out of Parkwood Woods, which looks like it was deferred up as assaulting a public officer or obstructing, where he got served 9 days ago. And that is it out of Michigan.
Anything further?
So I would also ask that he not be allowed to return to any public or private pools in the city of Royal Oak or parks, grass areas adjacent to it. Or have that.
Thank you very much. Mr. Angot.
Judge, as noted by the court, the presumption of innocence is absolute at this point. And so we must start from there. Mr. Stringer, or the person purporting to represent Mr. Stringer, is a business owner. Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
This is where reality hits hard. Notice how calmly the judge walks through the tier levels of the sex offender registry. That wasn't for dramatic effect. That was a legal warning. Tier classifications determine how long someone must register and how severe future penalties become. What's especially striking is that while the judge is outlining serious, life-altering consequences, the defendant isn't engaging with any of it. Instead, he's focused on trust law fantasy words like beneficiary and estate, as though the right phrase will magically dissolve criminal charges. Here's a question for you watching. Is this denial, confusion, or strategy? Let me know what you think, because the court clearly isn't buying it.
Thank you very much. The following conditions will apply to Mr. Stringer's release. Mr. Stringer will appear for all his future dates as directed. He will abide any valid order or judgment entered in this case. Mr. Stringer, you will not leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. You will notify the court in writing of any change of address, telephone, or email. Mr. Stringer will be making reports to pretrial services, and they will supervise his release. There will be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician, and Mr. Stringer will abide a substance abuse testing and monitoring program. No purchase or possession of a firearm or other deadly weapon. Mr. Stringer shall not harass, intimidate, beat, wound, or threaten Linda Marino and Chad Stransky, nor will he cause, through himself or through any third party, to have direct or indirect contact with said individuals. Mr. Stringer will not enter the cities of Royal Oak or Berkeley except for court, work, or medical treatment. And at this time, there will be 2 ETGs per week for control alcohol consumption and 3 controlled substance tests a month. Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this time. If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on right now?
I'm sorry, sir.
I'm being charged. I'm being charged an entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Now here's where the tone of the room changes completely. Up until now, this may have seemed like just another sovereign citizen doing courtroom improved. But once the detective lists multiple Texas warrants, assaults, weapons charges, and false ID allegations, this stops being quirky and becomes dangerous. Judges don't just look at today's charge, they look at patterns of risk. An history of evading arrest plus family violence is exactly the kind of pattern that makes bonds skyrocket. This is why sovereign citizen defenses almost always fall apart. Courts don't argue philosophy when there's a demonstrated threat to public safety. At this point, what bond do you think is reasonable?
Len Stringer, 24-01173.
Good morning, Your Honor. Samira Malus on behalf of the people.
Good morning, Judge. For the record, David M. Sunutko appearing on behalf of Mr. Stringer.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Len Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. I have an individual before me that is listed as an Oakland County Jail inmate by the name of Len Stringer. I have a case that's been assigned to this court that where the defendant's name is Len Stringer. Mr. Sunutko, are you assigned on this case?
I am, Judge.
Okay, and you were assigned to the Stringer case, correct?
That's correct, Judge.
Okay, so that's enough for me to conduct this hearing today. Now let's walk through this. Miss Mount Lewis, have you provided discovery to Mr. Sunutko?
Your Honor, I didn't have an attorney listed. I believe if he filed, he may have just received written discovery. I didn't have that in my information, but give me 1 second to confirm. I'm just going to make one click.
In the meantime,
I do have written discovery, Judge.
So yeah, it sees that he was provided with written discovery on June 26th.
Okay, so Mr. Sunutko, have you had a chance to talk to the defendant at all?
I did, Judge. I met with him at the Oakland County Jail.
All right, and so
Tuesday.
So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
Credit where it's due. Defense counsel is doing his job. His argument is straightforward. Tether monitoring instead of cash bond. But there's a massive problem. Judges heavily weigh reliability, and nothing screams flight risk like refusing to identify yourself, insisting you are a living entity, and accumulating warrants in multiple states. Asking for a personal recognizance bond requires trust, and the defendant has done everything but build it. The irony? Sovereign citizens often claim they don't recognize the court, but bond is literally based on whether the court believes you'll come back. If you won't even recognize your own name, why would they think you will?
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mont Lewis, can you prepare an order for competency review?
Yes, Your Honor.
All right. I agree. I think that that's appropriate at this time. I recognize that the defendant has made a request to have Mr. Sunuko removed from the case based on the information, though, that I've sort of observed at this time, as well as information received by Mr. Sunuko. I remain unconvinced that those statements are anything other than a manifestation of what might be a competency issue. And so I'm gonna wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sunuko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What label, excuse me,
What competency evaluation?
What labels me incompetent? My intelligence, because I have a high IQ.
And there it is, $50,000 cash with no 10%. That number didn't come out of nowhere. The judge just heard about violent history, public indecency allegations, potential mental health issues, and open warrants. This isn't punishment, it's risk management. Courts must balance presumption of innocence with public safety. The defendant's reaction is also telling. Instead of addressing the risk factors, he jumps straight to sovereign citizen arguments about dead entities. Every time he does that, he reinforces exactly why the court thinks supervision and high bond are necessary. It's not the philosophy that hurts him, it's the behavior attached to it.
No, that's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability
Nature of the proceedings.
that you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
Provided. I have a recommendation for pretrial services that suggests that there are untreated mental health concerns, and the nature of his criminal history and criminal contacts suggests that there may be significant mental health, untreated mental health issues. So, Mr. Stringer, I've heard your concern at this time. I'm not going to grant your request until I get a better idea of what your current mental health status is. So the request at this time is denied, but I will consider it again after an evaluation is done.
Hey, so who is the judge on my mental health? Because you can't obviously be a judge because, sir, I'm with my law, sir. So first off, I do not acknowledge myself to be Lindell Stringer, the corporation in capital letters. No, sir.
This is one of those moments courtroom watchers never forget. The defendant sincerely believes that by declaring his legal identity dead, the case disappears. But here's the reality check. Criminal law applies to people, not paperwork. The judge answers perfectly. Jurisdiction was established through sworn testimony and presence. That's it. No magic words. No secret loophole. Sovereign ideology treats court like a puzzle game. The justice system treats it like a public responsibility. And when those two worlds collide, Facebook Law School loses every single time. Question for you. Do you think he actually believes this, or is it an act to avoid consequences?
I appreciate that. And that's why I let you make a record, and I appreciate that. I just, based on what I've seen, I disagree with your position right now, and we'll get you evaluated.
You cannot.
That's enough for now. And then we'll have you evaluated by the evaluated by the forensic center, and we'll go from there. Thank you for Mr. Sunuko. Bond is continued.
Do we have a new date, Judge?
We'll set it 90 days out.
Very good. Thank you, Judge.
Thank you.